Hi, everyone. Welcome. Tonight, I want to talk about the Karen Reed case. Sorry, I didn't mean to do that countdown, but in any event, what I want to talk about from my perspective on this case is that I just want to talk about the case, about the evidence, about things going on. I want to talk about all the roles and players of the case, whether it's the judge, the prosecution, or the defense. I'm just telling it to you from my experience, having been both prosecution and defense multiple times and having a lot of violent crime cases. I just want to bring to you my perspective on things going on, because you all might not know exactly what's really going on behind the scenes or what's proper or not proper. So just wanted to share that with you. And so in this particular case, unlike the Markell case, where I've really been championing for the justice for Dan Markell and the surviving sons and the surviving family members of Professor Dan Markell. In this particular one, I'm just sort of like coming in here as a neutral observer. So I'm like just sort of looking at the case as someone that's just looking at it with an open mind. I don't have any preconceived ideas on how this thing should be shaped when I'm first coming into it. I'm just looking at it. What is the truth? What's really going on? And in this particular case, there are people on both sides of the fence. Some are definitely very much pro Karen Reed, and others anti Karen Reed that can't stand her guts. So I don't take any position like that either way. I'm just looking at it and I'm sizing up the evidence and thinking what is appropriate from the evidentiary standpoint, what is appropriate conduct for all the parties, as I mentioned, and just bring that to you. So the thing is, I don't have any super chat things on now. I'm not trying to add any super chats for this content, because what that does, it just distracts. So if you have any questions, wait till the very end. And if you don't catch us on a live stream, you may notice some advertisements that show up. Those are automatically going to be populated by YouTube. So I just recommend you guys join YouTube Premium. YouTube Premium actually has very cheap subscriptions for a year. I think it's like $15 for a solo and maybe $22 for a family up to 6. So anyway, that's what I recommend you all do. So what I first want to talk about is some general overview of different things going on in the case. I assume those of you following this case are now watching me, having not fresh eyes on the case. You have some experience on this case and been following it closely. So I'll sort of address it from that level. The one thing I want to say is, like, the Supreme Court opinion that denied the defense request to basically find that there is a double jeopardy issue, a Fifth Amendment due process type of challenge they made to the Supreme Court of Massachusetts that was supposed to prevent them from going forward on 2 of the 3 charges. As you may recall, all jurors did not believe that the case was proven beyond a reasonable doubt as to murder 2. On manslaughter, they had a mixed bag of voters. Most of them were pro-conviction, but we'll get into that in a minute as well. And then you also had leaving the scene of an accident. Those are like unanimous, not guilty as well. So, but the fact is, the Supreme Court mentioned in the beginning of their opinion that the defense counsel not raised the sufficiency of the evidence challenge. And I found that's very telling, because what is basically being suggested there is that if they would have had that, they would have taken the case and said there was not sufficient evidence to proceed. But the Supreme Court cannot decide something that's not before them, and they looked at the case law and decided that, yeah, we really don't have a quote unquote, foreman reading and announcing the verdict of the 12 jurors in open public forum that way. And so that's what the case law in the past has decided. So they really looked at it just from a strictly following the law kind of standpoint, not the equities of it. The equities of it, however, what is fair, what is right, what is just, those kind of things came into play, I believe, by talking about sufficiency of the evidence. And so by them not raising that as the defense counsel, I was somewhat initially surprised by that when I saw the opinion make that comment. But then again, I thought from the standpoint is like, well, you don't really see people taking a hung jury up to a higher level court, because it's such a rare issue to have jurors come out publicly after the fact saying, look, we were unanimous, and it's not what everybody thought, that we were hung up on all 3 charges. They were only hung up really in the end on the second one, but the whole process got convoluted. The jury instructions were sort of like hard to follow. And then there's also something out there that I understand is there's a former cop that was a foreman of the jury that wielded a lot of influence and made these folks on the jury believe that this is the way things are done. You can't individually look at charges, that you have to take them in toto in order to get a verdict announced. But obviously that's wrong. They could have came out with and said they're only hung on the second charge and they're ready to announce a verdict on counts 1 and 3. But that was never brought out in court at the time. And so the defense team for Karen Reed was trying to have the Supreme Court at least stop them from going forward on the most important serious charge, which is that murder to second-degree murder. So with that being said, I thought that if that's really true, that this foreman of the jury was a prior law enforcement officer that then got into the medical field, I'm just really surprised the defense counsel let a guy that had any kind of law enforcement background at all on the jury. That's something I would never do as a defense counsel. Something like that, if it's accurate, that's something I would recommend never happens for a defense team, because automatically they're going to be leaning towards the prosecution. And supposedly that's exactly what happened. They become sort of an expert and they can wield a lot of force in there. And cops are going to stick with cops, even if they're a former cop. And so I just don't understand why they would have done that. And I was shocked to hear about that. And I don't know for sure if that's accurate or not. But if it is accurate, that's a misstep by the defense. There's also this issue with Mark Betterow. He's an attorney that I guess was representing this Turtle Boy in his multiple felony counts. And I'm not here to talk about that case at all, other than the fact that now that he's joined the defense team, and the more I think about that, the more I don't understand why any defense counsel from either of these two sides would align forces. I guess it's not such a big deal for Turtle Boy to try to say, hey, I'm just trying to help Karen Reed. But for Karen Reed's lawyers to team up like that, I'm just sort of surprised, because that's just a big distraction, and it takes away from what you're trying to do for your case. And if Turtle Boy's out there making wild accusations, making some videos that are they're not professional, and some of them, I guess, were unprofessional enough that the law enforcement folks thought it was criminal, borderline, or was actually criminal in terms of harassing and intimidating witnesses to this murder case. And I don't have any more insight in that, and I don't want to talk about that. But I do, like I say, want to talk about this attorney joining and having that ability to know what's going on in both cases. It just surprised me, because if I was on Karen Reed's team, I would not want somebody affiliated with the Turtle Boy on my case and not have any kind of connection with that. And so that is something that could draw a lightning strike and unfavor. Maybe somebody's on the fence about whether they like Karen or not. And then if this Turtle Boy they definitely don't like, then that there could be some kind of spillage and carryover effect. So that's why I would not, me personally, recommend that attorneys cross-pollinate like that and sort of cover both cases as a defense lawyer, no matter what their role is, whether it's lead or third chair defense lawyer. I just don't understand why that is. I think from what I've seen of Mark Betterow, he's even been on YouTube with Turtle Boy, and so I just don't think that's a move I would ever want to see an attorney make that I was supervising. So what we also have is then I want to talk more about the way the court hearing went last week, where we had this issue where this grave concern the judge mentioned at the end, and it has to do with the fact that there were some representations made by the defense team, not just one, but I guess multiple lawyers, both Yannetti and Jackson, made representations with this ARCA accident reconstruction firm, and they represented that there was no contact other than logistics coordination type of contact. But apparently something that defense sent to the prosecution alerted the prosecution to say, hey, there's some also references of $24,000+ to be paid, or was paid by someone as a part of the defense to ARCA. And the implication is that maybe the attorneys were not being forthright and honest with the judge when they represented the dealings with ARCA. I think that is not going to have any bearing whatsoever on the case, in terms of these witnesses you won't find any more credible expert witnesses on accident reconstruction, then Dr. Wolf and Dr. Rentschler. These guys were really, really just straightforward. They just said it like it was. I think it's saddening to see that the jury did not know that the FBI is the one that hired him. And I thought that would really help build their credibility. But you see different stuff going on in the trial that actually hinders the truth from coming out. And in this particular case, the truth of that the FBI was the one that hired this firm would actually lend themselves a lot of credibility. They weren't looking for this case. They didn't know anything about this case. And they were asked to be brought in and provide expert analysis. And so that's something that that I think is what you see in the courtroom a lot. You see a lot of times when prosecutors try to keep out stuff that's really revealing and helps show the either whether it be the credibility of a witness, it bolsters the evidence that will bolster their background, their expertise. You see prosecutors will do stuff to try to discredit that, and then you also see things like just objections that are just absolutely bizarre in this case. I cannot tell you how many times I'm this like, wow, I cannot believe Lally made an objection to that. That goes right to the heart of the matter of what the jury needs to know. And it's like every time he knows a bad question for his side of the case, his theory of the case is going to hurt him. It's like he's saying objection, and then the way they don't have to say the basis for it, and the judge just will basically say sustained most of the time, and once in a while will say phrase it a different way. Me as an attorney, it's like I can see a perfectly formed question and that's asked by Jackson, and then I hear the objection, and the judge says to rephrase it or something. I have no clue how that could be rephrased differently or better, and the attorney's left not knowing how to change it. So I've never been a part of a court system where you're left in sort of in the dark of like, well, how am I supposed to rephrase it if I rephrase it the best way that's acceptable in any other court I've ever practiced? So I think practice in front of this Judge Canone is as a defense counsel, it's very, very troubling. It's very hard to work with a judge like that. As I've said before, I think a lot of her mannerisms, besides her rulings, seem very dismissive of the defense. With different questions the defense is trying to get out, if there's an objection, she'll basically ask the question instead of allowing the defense counsel to do it. I think that's in rare circumstances that could be allowed if there's really a trouble getting an answer out of a witness. But she just does it from the first juncture, and I just think that's very much makes it look like she's really pulling for the prosecution. The another example for Lally's objection and attempts to discredit the expert. For example, when in the report that was written up by ARCA did not talk about the fact that they actually did a controlled study in the same degree room that was 24 degrees as it was at the time they believed that John O'Keefe was in the roadway there dying. So that was the extreme level of detail they went to replicate the scene as much as they could. And of course, no kind of scientific type reconstruction like that is going to be 100% accurate in every single detail, but in all the material respects and details, I mean, they did an excellent, impressive job. This ARCA firm did. So, Lally said that, you never put this down, that you did that kind of temperature controlled study in your analysis at all. And he goes, well, we did. And so he kept on badgering him, like, well, you never put it in your report, and basically trying to make it out like the guy's a liar. So I just thought, this guy's not some hired defense gun. He's doing it for the FBI. And so for you to be able to have that protection of the jury not knowing that the FBI is the one that hired these guys as independent expert consultants, and then you're going to be able to turn around and make it look like they're somehow siding with the defense, I just thought was another example of how trials are not always about the truth or how things are packaged. And a lot of times as a defense counsel, you can have your hands tied behind you and things that are very important for the jury to know. The jury just won't get that information. And then you can have a bad result because of something like that. So indeed, I did listen to the one juror interview that they did talk about how if they would have known certain things differently, like they worked, like this firm ARCA was independently hired by the FBI, that would have been important for them to know and could have made a difference. So I think that would have been some additional ammo they could have used to help sway the jury that no, these guys are really credible. And if you compare them with Trooper Paul, I mean, he has no PhD. He doesn't have any advanced degrees in this kind of thing and kinetic forces and physics and stuff like that. So he's basically like a cop that just went to some additional training. He had 3 weeks of training and trying to do this, and he talks about 200 some case or whatever accidents he showed up to. But how most of those accident type cases are not involving criminal type setups, criminal type charges. And so if you have somebody that's not that experienced, it's not really going to matter as much if he gets it wrong, right? It's sort of like, well, it may depend who settles out on an insurance claim, as who was a major tortfeasor, who was more at fault in the vehicle accident. And then one of the other things is that the thing is there's an objection to different things that the defense was trying to bring out of these ARCA witnesses that really left to the ultimate conclusion of is there any scientific evidence that supports the prosecution theory that John O'Keefe was struck and killed by this SUV by Karen Reed backing up 24 miles an hour. And if you notice and go back and listen to the testimony, Lally's objecting a number of different ways, and he doesn't want the actual opinion to say there's no way. The doctors are basically saying there's no way, especially the Dr. Rensler, who's more the bodily injury expert on vehicle accidents. He basically was saying that there's no way that that the vehicle would have struck John O'Keefe without leaving significant more damage to his body. And so when what the objection wound up being sustained on, and what Jackson could only go back and ask him was, are these injuries consistent with somebody that was hit by a vehicle going 24 miles an hour? So there's a huge difference when you stop to think about it of is something consistent with somebody being innocent, or consistent with what the prosecution is trying to describe happened, or inconsistent with what the prosecution said. That consistent or not consistent, that's not really a strong thing to say, I think, to help show somebody's events that happened and show their guilt or innocence. So in other words, if they would have said, if they were able to say there is no way physically John O'Keefe's injury have any remotely sense and bearing to what happened in the prosecution's theory, that this vehicle and the taillight smashed into him and he went hit his arm, he went launching 30 feet further away. I mean, there's no way there's any comparable difference from that, saying it's not consistent, to actually saying there is no way that these injuries have any bearing in any relation to what we actually see on the person based on his experience, years of experience. And he's been doing this, I believe it was 16 years. And like I say, he's got multiple degrees. He's got a PhD in this field. And these guys are experts. I don't think they're going to do anything to put their whole livelihood at risk. And I know that there's some, they're going to try to use this issue that there was some kind of payment or whatnot. I think that's probably something that the defense witnesses did not have any kind of inkling that they were doing anything wrong. I just don't see that happening. Maybe the $24,000 had to do with payment for the upcoming trial. That makes more sense, because if they testified the last time, maybe it was part of their contract that they had agreed to testify in court to support their findings. That was the contract, and maybe that just rolled over and they agreed to do it because they didn't have to do it for the feds. And so now that they already testified, that was part of the original payment that they got for the feds. And now that they have a second trial coming up, I can pretty much assure you, from my experience, they're not going to do it for free this time, a second time. Okay. So they're going to ask for some money. So I think that's probably what this whole mix up is about, is they're talking about payment for future testimony, not something that happened in the past. Because I just don't see these guys risking it, sticking their necks out and doing something that's gonna get their integrity and their neutrality impeached in any way. So the other thing is, if you look at the actual number of objections, they're just ongoing and frequent. The tone of voice that the judge has towards the defense is sort of like, you guys are not trustworthy. Uh, and I even see her uh, casting big smiles to prosecution witnesses. And, if you can do that as a judge, that's one thing. If you're going to do it to every witness that shows up there, or do it equally between the prosecution defense witnesses. But um, and then twirling her glasses and stuff like that when a witness is up there. There's just so many things that just make it sort of cringe-worthy for me to think like, wow, this is like not coming across well as a neutral type setup, neutral judge for this case. So I don't care who the defendant is. I don't like to see that kind of thing going on where it looks like the judge is through the mannerisms, the comments, the rulings. It looks like they're really pulling for one side. That's what it looks like to me. I'm just giving you straight up opinion from my experience. And when you stop to think about how this case was botched up from the get-go, that nothing was really looked at with any open mind other than the fact that it must be Karen Reed. If you notice what Trooper Paul said, he was basically told where everything was at, and then he made a reconstruction based on what he was told. He did not arrive to the scene in a quick fashion where he's able to make his own independent conclusions. Everything was relied upon by what he was told of where things were at. And then what's really unique is that he testifies as if that's what really happened. Like all this stuff is hearsay, what he's relying on. Hearsay as an out of court statement offered to prove the truth of the matter asserted. And that's what he's actually doing, is he's giving his opinion on what other people told him, even though he has no independent knowledge of whether any of that's true or not. Now, I will say that the rules of evidence for experts, normally that, like I say, hearsay, that would not come in, although there's 24 exceptions to hearsay. One of the things that's relaxed is hearsay that's relied, or things that are otherwise not admissible um, through normal layperson's testimony. There are abilities to get that kind of opinion evidence out there with the use of an expert. So despite that being the case, so here, basically his entire opinion is based on stuff where he was told about placement of different folks. All right. So, and then for him to explain how this um, John O'Keefe body could be launched 30 feet after being struck by a tail light, it just makes no common sense. Absolutely no common sense at all. It's just something that you don't need an expert to understand. And I've seen enough collisions. I've been a part of different collisions and whatnot in my lifetime, and I just have that. To me, what's common sense belief is that if he would have been hit by a car like that, it would have been way worse damage, way worse. And so when you look at other things going on, like with the Sally Port inversion of the tape, how did that happen? If you look at if you study what the back tail light of Karen Reed's SUV looked like when it was being hauled away by the tow truck versus how it looked at the Sally Port, there is a difference there. I think there's a major difference. I think it's readily accessible, really quickly discernible that something else happened to that tail light. Who did it? We'll probably never know, but it definitely was altered. And so the question is begged: why would somebody alter that? What's going on? And why do we have an inverted videotape that was not discovered until the trial happened? And that thing is really major to have that inverted video. And and so for that to also to have different time date stamps affixed to it, that's something that I'm really surprised that if you compare that to Alec Baldwin, I saw a comment on that earlier today. Like if you compare Alec Baldwin to this case, Alec Baldwin, same kind of thing. Some evidence was not turned over to the defense, and it was not considered relevant, and the judge dismissed it with prejudice. The charges against Alec Baldwin here, there's like multiple things going on, and in the evidence in particular being altered to such an extent that it really makes you scratch your head and makes you think that something else is going on behind the scenes, and and there is no way, from my opinion, there's no way. I don't care how this turns out. I don't care even if there would be a jury that would buy this incredulous story of what the prosecution is making out to be a secondary murder case. There's no way this case is going to stick on any kind of appeal, and there's not a sufficient evidence to have any reasonable juror believe that that this was a secondary murder case. So, um, and keep in mind, the defense also have to do. If you're up there, you don't have to present any evidence to show your innocence. And in this particular case, obviously, they are going to fight and try to present evidence to show that it wasn't Karen Reed, but that it was something else that went on. They use the word framed, and the word framed has to do with basically planting evidence on somebody or manipulating evidence or fabricating evidence to make it look like an innocent person is guilty. And so that's the word they're using in court. At first, I would think that that's sort of a strong word to use if you don't have really proof of who did it. Then I don't know if you want to use that strong a word, but when you look at the different way the case is laid out, like I say in particular, that Sallyport video, that is very troubling and disturbing. And when you consider the officer Paul testimony, there's nothing credible about what he's saying that adds up to lead you to believe there's a secondary murder case here. So, with that being said, I think what's going to happen in the hearing in the next couple days, having to do with this issue with the lawyer. Do I think that Alan Jackson, if he did misrepresent the court, could he be gone? Could he be denied the pro hoc vice, which is a Latin term? It basically allows him to temporarily be in a Massachusetts court, even though he's a California lawyer. It allows him to sit on this one case and one case only. And one of the things you have to do is represent to the court your ethical background, whether there's been complaints, any substantiated complaints against you, and if this is a complaint against him by the Commonwealth, and he's found to have conducted himself in a unethical manner, then he very well could be told to be removed from the case. The one thing that even if he did do this, which I find it hard to believe an attorney would actually do that on a high profile case, especially, and somebody that's got his kind of experience. So I'm not coming to any preconceived ideas on what the actual ground truth of this is. We'll hear more at the hearing and figure it out from there. But I just think that him having to realize that he could be yanked from this case, is that something an attorney would do? I mean, yeah, I've seen crazy stuff. So is it possible? Yes. But if this is really indeed what happened, the one thing that's going to keep him on the case, even though the judge may find him in contempt, is the fact that he's the lead counsel, or at least looks to be the lead counsel for this Karen Reed trial 2.0. And so if this trial is coming up 1 April and he's tossed as an attorney on the case, that could move that whole trial date. So I think that's the reason why the state would not be as inclined to get him off the case. But maybe there's enough bad blood there that they want him off the case. They think he's too good of an attorney to basically have on the case. I'd rather have somebody less experienced, less effective. But there's stuff that he does that I've seen that that I think that sort of surprised me. I thought he would do a better job on certain things. So, and I can go over that later with different witnesses and whatnot. So for now, I'm going to go ahead and leave it at that. And if you guys have any questions, I'll go ahead and take questions now. If you do have questions above, please go ahead and post them now. Yeah, and Nancy, you are saying justice for John O'Keefe and Karen Reed. Yeah, basically what I'm doing is talk about what's really the just thing here. Because if you're going after the wrong person, you don't have enough evidence there. You're building things up and hyping things up. They don't need to be there. Okay, Judy Silva Delgado, you're saying backing up at 24 miles in the snow is excessive in my experience, don't you think? In my opinion, she's guilty, not murder. However, it was an accident that she caused. She won't be found guilty. Okay, so I would just say that there's that in and of itself sounds like it could somebody backing somebody at 24 miles an hour look like somebody's mad or something like that? Does that automatically equate to murder? As we heard from the one juror, they were saying that, well, she was there at one point in the time and She must have been mad at him. So we just got to attach some kind of guilt on her. Well, you know what? You need some kind of proof, more direct proof to find somebody guilty. So I think that's why you agree that she won't be found guilty. So obviously, there's some things that you can believe that indicates that she's guilty. Like she says, I hit him, I hit him, I hit him. So it's really about, could somebody say something like that when they really didn't hit him and they're just in fear of maybe, well, did I cause this? A lot of people have that type of thinking, like, oh my gosh, what did I do? And so they have that fatalistic opinion and they make blurt out comments like that. So I don't really put a whole lot of stock in that per se. I'm looking at the forensic evidence. If the forensic expert evidence on kinetic force and bodily injury does not line up with the physical evidence that the cops have, then that doesn't support that theory. In fact, these witnesses are so credible, these experts are so credible, they absolutely are unimpeachable. I just think whatever they say, I don't think they have any skin in the game. You know, Trooper Paul, think how much pressure he has to say what he did say in the court. That's something that was not brought out by the defense, which is you are you are a law enforcement officer in the state of Massachusetts, and you work with the Canton Police Department, folks, right? So he's been working there. I don't remember how many years he's been working there with him, but I think it was only been assigned 8 years as a cop. So for him to have 8 years experience, and he's sort of still, I guess, green in the accident reconstruction stage. But here you have an accident reconstruction involving somebody that you work with out of that same office. If that's not sort of a conflict, I don't know what is. Rosemary Gallagher, you're saying Arca already said the car didn't hit John O'Keefe. Yeah, and but keep in mind that they weren't allowed to say what they really thought. They just were limited to say the injuries to John O'Keefe were not consistent with the SUV striking him. Right. What they really were trying to say, and what they initially first were being asked by Alan Jackson was, is there any way these injuries could have came from the SUV? And they were trying to say, no, there's no way. So they're that convinced that this vehicle did not strike John O'Keefe and cause him those kind of injuries that we did see on John O'Keefe. So that's to me, it's the denial of justice. Now, it's one thing to say. I know as a prosecutor, if you have an expert testifying that something is helping prove your defendant guilty, you cannot say bring an expert on to say, yeah, the defendant's guilty. That's something that's not allowed for prosecutors. It should be allowed for defense if they're talking about forensic evidence. Say there's no way, shape, and form that this injury was caused by this SUV in question. That should be totally allowed by the defense, and yet it's not. They're only allowed to talk about from the consistency with the strike or not, and that to me is a huge gaping hole of lack of accurate and truthful information that's being blocked from the jury hearing that. And so why is the prosecution objecting to that? Because he knows that helps show they got a loser of a case. And so that to me is very troubling. Okay, Marta Fonda, you're asking a really strange question given that we love your podcast, but does the intervention of podcasting in so many recent trials, in so many recent trials, you were from either a prosecution or defense standpoint? Intervention of I don't. I'm not quite following your question. I'm sorry, but I'm just telling you. I'm calling it like it is. I come into these cases neutral, and then I form my opinions based on my experience. I can look at a case very quickly and size up what happened, and then I basically look at all the detailed police reports and all the testimony that comes out. And you really, these things are not too difficult normally to figure out. Um, whether you got enough evidence to charge somebody or not, or whether the charged person you're defending, whether they have a chance of getting it dismissed or acquitted from a jury. So So anyway, I'm just still trying to have that. I do talk about the evidence on this particular case now from all sides. The Markel case, I'm not doing anything to help the defense, so I'm not being fully full disclosure on those kind of things here. I think that I'm more at liberty to discuss all my thoughts on it because I think that in the end, there's nothing I'm saying that's really going to help the defense so much or hurt the prosecution. I'm just telling you that this evidence is going to crash and burn, no matter where it gets heard, what kind of jury it gets heard. It's not going to survive at the end of the day, and that I can assure you. There's no doubt in my mind. There's no way a conviction for murder will stick on Karen Reed. Empty pockets, you're saying John was beat up. No way he was hit by a car. No injuries below his head other than scratches on his arm, which are dog bites. So that's something that, the injuries are more consistent with that, I believe. I don't know for sure these are dog bites. I've not had a dog bite injury case. I've seen someone almost mauled to death by dogs, but those were different kind of a situation there, where the arms were bare. I don't know I don't recall um, why a dog would have those kind of marks if there wasn't more clothing on. So, in any event, Andy School, how allegation means she was drunk, able to reverse on a curve and hit a target that's living, breathing, and not dead. As a trauma RN, I can say with medical certainty, innocent. You agree? I would say that the uh, the evidence does not align up from a forensic scientific standpoint with the vehicle striking him. If it didn't strike him, I mean, do I know for certain? Can I say for certain that she did not get out of the car with a bat and beat him over the head and have a dog there to attack him? I don't know that that's not a possibility. So I think to say that she's innocent, I don't know enough details, and we won't never know enough details. All I'm looking at is what proof is there to say that she is guilty of murder or that she intended to hurt him in any way. So the physical evidence does not align with what the prosecution's saying. And for them to go after her a second time, knowing that they couldn't convince any juror that she's guilty of murder, second degree murder, it just shows you they're out for blood. They're out for blood. The prosecution is. Jerry Labette saying, "Did you catch that? Commonwealth got it wrong, and what he was holding up was not from the feds, but from the fence." Yeah, I did catch that. They said it came from the defense. This some emails and whatnot. So it could be a big whole smoke screen that they're trying to get the judge to be confused about what was going on in communication between the first trial and now the second trial. Clerk Jim Clown is saying even questioning Alan Jackson is kind of a farce when Hank gets to stand up and make claims unsupported by affidavit and then gave the judge cancel the hearing without a lying response. Yeah, I thought that was really weird to suddenly abruptly cancel it. I thought it was leaving all us out there hanging. What's going on? Give us more details. And now she wants more information about the communication between the defense and ARCA. So um, I I wouldn't be surprised. This whole thing is just basically a big a big diversion by the prosecution. Brandon's body chalk. You're saying Was a D out of line for that video? You sent it to me. Could you please resend that video? Because I have not, I don't recall seeing that video, but please send that. Rosemary June, you're asking what 3 excerpts would you consider adding if you were the defense? Apple Health data expert for one, perhaps. I think there's other angles I could use from the defense perspective, and I think some of it is I think what's most important is pushing back on this issue about not consistent with the prosecution theory of how John O'Keefe was killed. That is so much a neutralizing effect on these 2 experts for ARCA that it really could make this whole case turn on its head. If they are allowed to give their full testimony where they can say, there's no way, based on all of our experience and expertise in this area of physics and biomechanics and kinetic force and the effects on the body and vehicular motion and what that can cause for strikes on different plastic components of vehicles and what it takes to create that kind of force. That I mean, this is an open and shut case. It's an open and shut case. They don't have a murder case here at all. They oversold it, and I think the Supreme Court would have bounced it if they would have asked for it to be bounced. And I think like one of the things that was said by this Dr. Rensler was that he said one of the things that they looked at was an 11-pound head uh, being hit by a vehicle at 15 miles an hour. Compare that to the 24 that's alleged to have happened with Karen Reed's car. It produces 1,000 pounds of force against a body. 1,000 pounds striking John O'Keefe. Then you ramp that up to 24 miles an hour. That's going to cause way more than 1,000 pounds of force. It's going to leave massive bruises on his body. And he didn't die right away, so he had a chance for bruises to form on his body. There'd be massive swelling. There'd be broken bones. That's just this is so telling and revealing. When I heard that testimony from him, so I think that there's I know there's like maybe a weather expert that's going to testify for the prosecution. So one of the things that they could look at from the defense is from the standpoint of what kind of bodily injury expert could you also add to this kind of thing? And you could even have an ER doctor testifying. It doesn't have to be somebody that's like kinetic force. From your experience, what kind of injuries happen from vehicle accidents where they or MVA where they strike a pedestrian kind of thing? So even another medical expert like that could testify to that. But I think when you look at it from the scientific standpoint, somebody from the ER in the medical field, they're not looking at it from the scientific standpoint. They're looking at solely from the standpoint is how do we help this person survive this injury, right? So that's why this Dr. Rensler is so critical and such an important witness because he can talk about all this wealth of knowledge, and you're not going to find somebody better. Can the prosecution find somebody with Rensler's credentials and refute Rensler? There's no way that's going to happen. Okay, there's no way. I can guarantee you're not going to find somebody that's uh, can recreate that and say no. You know what? This is consistent. Everything that Trooper Paul's saying is accurate. And like I say, it's all fed to him by Investigator Gallagher at the scene. It was never independently discovered by Trooper Paul. Okay, Icy Ducks, you're saying the video towing her car shows the car backing up the ramps, wheels spinning in the snow to get it up the truck. Yeah, I think it took them 1 or 2 times to get up the that steep ramp on that tow truck. You're saying that's 24 miles an hour. I don't think the date stamps would have matched up with that. That would be true if there was a date stamped on the vehicle, but I think there's a date time stamp on that vehicle that would make that not an accurate assessment. Otherwise, yeah, that if there was a match of time, then yeah, I would say that would be the most logical conclusion. Yeah, Rule Thomas, the accident spoke to me. Trooper Paul testimony. Can you imagine? Like I say, this is something that one of the things I noticed that Alan Jackson didn't flesh out was the uh, the back the blue type of pressure and the code of silence and that kind of stuff. I would have really hammered him on that. That you got to say what the investigators said happened, right? You have to. You're basically a traitor. You're betraying the force, and you're dishonoring the death of a fellow comrade, law enforcement comrade, by not agreeing with what they told you happened. So that's something that I hope is brought out on this next trial. The part about the accident spoke to me. I mean, that right there shows you this guy doesn't know what he's talking about, right? The accident spoke to me. No, it's more like the investigator and the other cops spoke to you and told you what to formulate for your opinion. I do have a suggestion for the defense with Trooper Paul that I do not want to say here because if it ever gets back to the prosecution, how this could work, I'm concerned that they would try to do something to prep Trooper Paul. So, in any event, I may save that for later. But I think there's a technique that I use for somebody like Trooper Paul that would really show that he doesn't even believe what he's testifying to, you know. So I think that's what's really something. He's so nervous, and it's just so obvious to me he doesn't believe what he's really saying. He's trying to believe it. He's trying to go after these different data points, but he's completely in over his head, and he's in over his head being a conflicted witness. Okay, Jane, Kreisman, you're saying sorry, but Carlto's last summer, his then girlfriend was a free Karen Reed and he was siding with her. I did not say that, number one. I told you I was having my now wife review the testimony and I was listening to only bits and pieces of it. And I was asking for details each day. Is there any summation that can be presented? So, in any event, so the bottom line is we're just talking about the case from a neutral standpoint and how the evidence shakes out. So to say we're on this FKR bandwagon, Leslie and I, that's not the case. We're just talking about the evidence as it speaks out, as the evidence cries out. So in any event, that's all it's about. So don't make it look like I'm some on some bandwagon soapbox trying to create some kind of thing other than what I'm doing, which is talking to you as a lawyer. Do you want to hear it from a lawyer or do you want to hear it from a troll? If you want to hear from a lawyer, then you can listen to me or other lawyers that are talking about it. Or you can listen to some kind of troll that's not a lawyer, doesn't have a clue, and just has some agenda. Okay, my agenda is the truth. And I don't care where the evidence lies. I can talk about the good and the bad and the ugly about all players in this case, where it's the witness, like I say, the judge, the prosecution, or defense. I'm just telling you like it is for my foxhole, based on my many years of uh, cases. I'm going on 35 years as a lawyer, and I've tried many cases of prosecution and defense. So that's what I'm going by, and that's all I'm going to say about that. Nikki, you're asking the new Karen Reed habeas lists the Attorney General's office as a respondent for the double jeopardy issue. Could that be an issue if the Attorney General's office uh, is working with the FBI in the corruption investigation? Well, I think that this habeas thing, the fact that it's brought in the federal court, and the federal court is going to now be looking at this as well. It's maybe the federal court will shut it down before they even get to the April 1st trial date. And so, in any event, I think something's going to happen to get this case derailed at some point, whether it happens before trial, during the trial. it's just an absolute hot mess, bizarre case that, because you have a cop involved, they're going to prop something up, and they're not going to back off this unless somebody else intervenes from the Attorney General's office or the FBI. This ludicrous prosecution theory is going to continue to have legs and keep moving forward, no matter how many times they got to get slammed by a jury or some kind of appellate court. Mr. Monk's understudy, you're saying, can defense make a motion to be able to say what they want with ARCA? I would make an emotion to say that you're denying a critical piece of evidence that could make the difference between guilty, not guilty for Karen Reed, which I guess in the end it won't, because the evidence is so ridiculous. There's no forensic evidence to support the prosecution's theory. But I think this whole issue about not being able to say more than that the injuries to John O'Keefe are not consistent with the vehicle strike, to me, is so much watering down the truth that it's really a blatant miscarriage of justice, and it's a blatant violation of due process. And I don't care what the case law says about it. I think if Massachusetts doesn't allow that kind of testimony, it's a very sad day for defendants that have expert testimony that can completely refute the forensic. And like I say, if they have prosecution witnesses and experts that can say, no, these are completely consistent with it, and that's all they're allowed to say, that still works fairness to the defense. Okay, so we're not allowing somebody to say somebody's completely guilty, but if there's forensic evidence that completely lines up to refute the prosecution's theory, that all that type of evidence should absolutely come in. Anna Shaw, why did the defense have to prep ARCA? Well, anytime you're going to call a witness, especially an expert witness, you do want to know, have some kind of dialogue and what kind of questions you're going to ask them. And because you don't want to waste the jury's time. I mean, a lot of these questions they're formulating in court by the attorneys on both sides, I might add, it's sort of like they're on a fishing expedition. It's like they don't really know the answer, and they're sort of just moving along, trying to poke holes in the witness testimony. Here, if you have a chance to interview, sit down with somebody, you can have more straightforward questions. The witness, whether it's expert or not, they're going to understand what you're driving at, and you're not going to have this fumbling around trying to have a question asked the right way and rephrasing it and all that kind of stuff. So, and also what they a lot of times do is say, hey, the other side's going to probably try to attack your testimony, saying this, that, and the other. How would you respond and whatnot? So, those kind of things are routinely done by attorneys that are preparing for trial. And some just flat out don't even prepare at all. They just bring a witness up there, and they get surprised a lot of times, and the witness actually can be flipped against them when they think it's going to help them. Law and lit, you're saying, why is the judge allowing so much evidence without proper chain of custody? That's something that is I guess telling for this the way the crime scene was processed. I mean, they're using solo cups and stuff like that. This is not a processed crime scene. It's a complete disaster, and you will not see something this juvenile, this outlandishly, um, it's just mind-boggling that of all people, a law enforcement officer cannot have a forensic team there to really decide what happened, and that they didn't go there and secure the scene. They didn't go in and interview witnesses at the house across the street, the house that's happened at in their front yard. So it's just mind-boggling, and how Trooper Proctor right away came to the conclusion that Karen was the one that was guilty. It's just, and then the level of his degree of hatred and bias and prejudice against Karen. I mean, you don't see this kind of stuff coming in a courtroom much, where a defense has that much ammunition against one of the main prosecution witnesses that he wants the defendant to die, and you're supposed to have neutral eyes to observe and investigate and gather evidence against the perpetrators of this crime. I mean, what you have when you have that kind of conduct is that it really is a prejudice to somebody like Karen who you're going after. But let's just say that more evidence comes out later that somebody else did it. There's another theory of how John was killed. You've gone after somebody so bad that you've lost credibility for that case as well. So I've never seen such an open and shut case of a trooper being absolutely having the amount of misconduct that he should have been fired before he even came as a witness. That's how bad his behavior was. Trooper Proctor should have been fired as a witness before he even testified in the case. What happened only after all this stuff came out of these private text messages from Trooper Paul, from Proctor came out, and that was because the FBI data dump, the 3,000 pages that the FBI turned over to the defense and prosecution, and because of that, they otherwise wouldn't have known this. If think about it, investigator Trooper could have presented himself as like this honest, law-abiding, straight by the book kind of investigator, and meanwhile, you had all these nasty vile comments about Karen Reed and how he wanted her to die and all this other stuff. And so even once that happened, the state had that in their possession. The district attorney's office had that in their possession. They should have been taking action against them. But what I see time and time again is misconduct by a key government witness will be buried. It will be buried and never raised again, or will be something that is brought out after their testimony at an important trial, because they know that's something that's going to damage their case. But what they have a duty to do is do right by the citizens and do right by justice and make sure people like that aren't on the street investigating cases. So he was out there being able to do more things of this nature to other defendants potentially while this case has been pending. All because why? Because the prosecution wanted to try to like package this case the right way in front of a jury. So as we now know, he's been suspended, and the ultimate outcome, whether he's permanently terminated as a law enforcement officer or not, I can tell you he will never have any credibility in another court of law in any other case he follows up on if he's allowed to be a law enforcement officer. Okay. I mean, he's pretty much, if he's allowed to stay on as a cop, it would be desk duty. Okay. You're never going to be able to testify in court again. By using that degrading comments against a woman defendant and having that much hate and nasty talk about her, that's absolutely so cringe worthy of you never being a witness again in a court of law. Joe Moy, you're asking how can I explain how or why the FBI became involved in this case? They might have taken their own interest in looking at this case because there's so much media attention. And keep in mind, there is a lot of different types of corruption around different parts of the United States, some more than others, where you do have cops that are basically doing stuff that's basically along the lines of organized crime to some degree. We have multiple cops acting either alone or in concert with others. We also have had that in the military before. We've had, the whole MP office, a lot of folks dealing drugs at Fort Bragg, North Carolina, years ago when I was there. You've had, any number of cops uh, stealing drugs off the defendants and using the drugs or selling the drugs, and there's a lot of issues of misconduct of law enforcement. So they're not always what they're sworn to uphold. So that's what I think happens, that they got some inkling that something's not right here. This is not adding up, and so there could be still sealed indictments going after some folks. But FBI moves pretty slow, and so we don't know if anything's going to develop. But it is good that they did turn over this report. I think that is very helpful to have impeachment and show what really went on. Because I don't think that you would find better experts in ARCA, and so I guess the defense never would have been able to use somebody like them. But if with all the money they're paying for the lawyers, you think they'd be able to hire some of the best experts money can buy. So in any event, CW, you wrong. Yeah, the injuries are inconsistent. Not hit by a car. I agree with that totally. Jane, you're saying Rajman would say Carl's missing a lot of the puzzle pieces. Okay, this is embarrassing soon. Yeah, it is embarrassing for the prosecution. I agree. I don't. I'm not following what's going on with these different trolls and whatnot. I'm just trying to talk about the evidence of the case. Amanda Ronick, you're saying the condition of John's body proved he was not killed by a car. Yeah, that's what it comes down to. The state would have to prove that, okay, was it some other method that you're going to say that Karen Reed killed him? Or are you going to try to say, like I said earlier, she jumped out of her car, took a bat, and hit him over the head, beat him unconscious or something like that? I mean, that kind of physical evidence would make more sense, but there's no indications that's what happened. But Leah, you're saying is that you consider the fact the federal court set a court dates so quick, very positive. I do think that that is a positive sign, and like I say, I think you get somebody outside of the hive mind mentality of somebody tied in with the Canton Police and State Police and the District Attorney's Office. You get somebody outside, any neutral observer, true neutral observer like myself, they're going to come to the same conclusion that this is like um, they have no chance of securing a secondary murder conviction on this case. It's to the manslaughter. I don't think that is as well, because in order to get the manslaughter, under the state's theory, she hit him with her car. What the forensic evidence shows that the car did not cause that damage. So how else? What else caused the damage? The state has to prove what else caused the damage. So you need more than what they got. Way more. Mondo Enterprise, you're saying there's too much reasonable doubt for me as a juror. It doesn't mean she didn't do it. Yeah, like I say, we don't know. Could she have theoretically done it some other way? We don't. Could she have unleashed a dog and had it attack him or something? We don't know those kind of details, but it's up to the state to prove it. If they can't prove how he was hurt and killed in a way that makes common sense attach, then they have no case. Law and Lit, you're saying, you ever seen a prosecution so set on pursuing a case with insufficient evidence? Isn't it obvious they have some other motive? I can just tell you that uh, it doesn't even have to be a case where it's tied up with law enforcement as a victim here. You can have a case where the prosecution, they're just unrelentingly trying to go after somebody, and it makes no sense whatsoever. And that's why I like juries. I call juries the equalizer for all the impure motives, the vendettas, the railroad jobs that are going on. And so the folks that are doing dirty stuff behind the scenes, a lot of times they don't want their stuff being shown out in the court of law. And think about it. Think about how this case is showing how bad cops can really be. When you look at Proctor, I mean, do they get any worse than that? And then you got Trooper Paul, him as a crime scene expert, reconstructionist. That's all the state has for credible witnesses. It's just very much and then they're going after a second time, even though they couldn't even prove it by one juror. They couldn't even get one juror, including the alternates, to believe that Karen Reed was guilty of second-degree murder. So that right there shows you that they are just hell-bent on doing something to try to make them look like we believe it, we believe it, we believe it, and yet nobody else believes it. We're going to still keep believing it. So instead of sitting back and reassessing and saying, you know what, maybe we did overkill and by charging her secondary murder. No, as soon as the verdict was announced or the hung jury result happened, mistrial was declared. What did they say? They got out and said, we're going to retry everything all over again. That's not a smart thing to do. The smart thing to do is to regroup, reassess, and hey, did we have tunnel vision? Are we too close to protection of law enforcement that we can't see the forest from the trees? Do we need to step back and really reassess and think about the credibility gap that there is between an expertise gap there is between the prosecution and defense witnesses? January 33, you're saying, Hank, you're talking about Brennan, the current prosecutor, former defense attorney turned prosecutor for this case, smeared the defense lawyer and the doctors were not given the right of reply and allowed the media to hammer their reputations on Karen. It's not fair. Yeah, I mean, I think it's very strange. Why was there, that could have been dealt with right away. It could have been dealt with and cleared up within a minute or less. But why the judge want to take a break? Say we're just coming back and doing this next week, and so it's just I just don't have any kind of confidence in this justice system there in Massachusetts. Daniel X, you're saying it's mind blowing that people still think Karen Reed is guilty when it's been scientifically proven it's not possible. So it's not possible that she hit him with her car. So yeah, the state's theory is basically on wing and a prayer because they got nothing to back it up. Andy School, you're saying I've seen worse injuries on a dude tossed from a car at 12 miles an hour than John O'Keefe's injuries. I specialize in forensic pathology. Then admin had me begin lecture circuit there. Staff is usually not to be called. Yeah, so that's interesting. Another person with some kind of expertise in this says again, these injuries are not consistent with what the state's saying happened. David Capana, you're asking counselor in a soundbite, what is your opinion of Karen Reed? What did she do or not do? What is the evidence to prove? Okay, first of all, like I said at the beginning of this live stream, I don't have an opinion of Karen Reed one way or the other. I don't know much about her personal life other than what's being presented in this trial life. I don't know if she's likable in her personality much. I have not really seen her make much statements outside the court. I do think it's sort of telling though that a defense lawyer allows her to speak to the media like she is. That's normally a no-no for for defense lawyers to allow your client to speak to the media. You got to really trust in your client's innocence to allow them to speak to media. I will tell you that. And Alan Jackson, experienced lawyer, so for him allowing her to testify and make public statements like she's been doing, that to me is like that's a high risk maneuver because a lot of defendants can get tripped up in that. And so it's a high wire act for defense counsel to allow her to make those statements. But if you really believe that your client's telling you the truth and they consistently are telling you the truth and this forensic evidence, scientific evidence backs up their story, then that's a risk they're willing to take, and it probably is helping folks get on the free Karen Reed bandwagon. Miriam Kamuji, you're asking, is it common for a judge to require defense turnover to prosecution all prosecution witnesses impeachment info / evidence? Judge can only require it in the first trial, and Commonwealth has motion pending to require it again. Yeah, I think there's it all depends on what the reciprocal rules of discovery are. And I would say even if you have reciprocal discovery signed with the prosecution and defense, they have to turn over all the exculpatory type of information, which is called Brady. It's a Supreme Court case, Brady v. Maryland, that's been decided for many decades, and then puts the onus on the prosecution to turn over all evidence that has any remote chance of being exculpatory and helping the defense. The prosecution is supposed to pick through stuff and say, well, this sounds like it's supporting the defense, but I don't think it's credible, so I'm not going to turn over. No, you basically need to have an open file system to keep your nose clean as a prosecutor and not have any chance that something is omitted. And I'm just thinking right now of a case where a prosecution, there was a key document, a one-page document that came out in a hearing that I asked a witness, why didn't you have you ever had this happen to you? And they said yes, and it had to do with prosecution. and that they were actually read their rights beforehand. And so that was the kind of thing that the prosecution had not turned over. So it made a huge difference in the case. Ultimately, that one didn't go to trial. But yeah, I see prosecutors doing stuff all the time that you just wonder why do they do that? They're supposed to be on the side of justice, and it just burns me up. I can't tell you how angry I get seeing this Lally guy. I don't know if this Brennan guy is going to be much of a obstructionist for the truth coming out, but man, Brennan was excuse me, Lally was just terrible to listen to. Very very much burns my hide. Excuse me. Mary Romine, you're saying see June 10th, 2024, Hank live. It's all on film. June 10th, Jack said it all back then. Hank lied. Arca hired after February 26, 2025, like 18 days ago. That's what I think happened is that he's mixing up when they were under the ability to testify without being charged because that was part of the FBI contract that he had to not only investigate but be available to testify about their findings. Excuse me. And so they're not going to testify a second time around. So that's why they need to be paid. So that's what's going on there. My belief is that's from my experience, that's what I think happened. And if it turns out something different and he did lie to the court, then obviously that's going to change the whole trajectory of this case potentially. But I don't think it will. Okay, you're saying you don't believe in science in the same class as Trooper Paul. Um, so okay, Jane Kreisman, you're saying when does a defense ever need to manipulate evidence when their client's innocent? Can you tell me what evidence you're talking about that was manipulated? Does that speak for itself? Well, first of all, if a defense attorney is doing stuff that's not proper, ethical, you can't impugn that to the defendant, right? So you may just have a bad lawyer. The lawyer doesn't know what he's doing, or the lawyer's going an extra mile to try to get a win by doing something shady. So what shady thing are you talking about? Can you enlighten me on that? Um, then you're saying can they avoid out double jeopardy because the first defense was fraud? I don't know what the first defense being a fraud is that you're talking about. So again, it's those are sort of like sound bites. I don't show me what exactly you're talking about rather than just a sound bite phrase like that, please. Okay, here we have a YouTube code of ethics officer. I'm so 50-50, but the broken tail light sure lines up with the cuts on his arm. Well, you need to look at the video, please, and see for yourself. Why is there much more of the red tail light smashed out after it's hauled away from where the vehicle was parked that morning? Why is that? Why is that so much more smashed out? Okay. And are you saying you know more than what these experts do with a PhD? Do you have a PhD? Could you state your credentials? Because if you don't have a PhD in kinetic force and how it relates to bodily injury from being struck, then I don't have that kind of experience, but I do have common sense. And it just so happens my common sense is telling me that before I even heard those experts. Okay, so we can disagree, but bottom line is there's no expert that's going to agree with you. I can guarantee you that there's no expert. Okay, and that's ultimately what's going to come down to. There's no expert that's going to have the caliber and expertise that ARCA has. And Shaw, you're saying 11 people in the house and all got together to murder him for no apparent reason. Well, they don't have to prove that's what happened, and we don't have to know that for sure what happened. That's what some people will believe that has happened to John O'Keefe. I mean, his injuries are more consistent with him getting in a fight than anything else. Okay, I will tell you that, friend. From the many violent crimes cases I've had, that's what my opinion is. Okay, and that seems to also be consistent. To use that phrase, consistent with what the experts for ARCA say. And so I will tell you that there was, I've seen a guy jumped at a party, and a bunch of people were out to set him up, and he was invited to a party, and he got ambushed and beat up, and they all claimed that he's the one that was fighting them, and so in any event, um, you can't believe what's capable out there. Okay, so if you automatically think that is not possible for 11 people in the house to get together, and no, it doesn't work like that. What can happen is things get out of hand. It could happen right away, where maybe one blow to the head knocks him out, and they think he's dead, so they throw him out by the curb, thinking somebody's going to intervene, and then nobody intervenes, and then next thing you know, he's dying, and they think surely somebody's going to pick him up, and then lo and behold, he's dead. And then it's like, oh my gosh, what do we do? We were all in the house. We knew what happened. We didn't call the police because we're police ourselves. And I mean, that could have happened. I don't know what exactly happened, but those kind of things spiral out of control. And then you have a cover up happen after the fact. So that is my experience being in the military. I can assure you, cover ups happen all the time. Okay. All the time. And they happen by the highest ranking people as well. Okay. People that you think had have zero motive to lie. You're talking about people that are, way up there with multiple people, with senior executives, generals, that kind of thing. You think that, you think like I would think like you say, these people have no reason to lie. Why would somebody ever put their career on the line to help cover up a crime? And it happens. It happens that by people that maybe have never had the inkling to do something like that. But if something that saved their neck and look the other way, yeah, they'll do that. And then if it comes out that, hey, were you part of the cover up? No, I wasn't part of the cover up. I didn't know anything. So I've seen that happen firsthand. So anyway, so it's not like they have letting people decide ahead of time. Hey, let's go beat this guy up and kill him and throw him out there, let him for dead, and then we'll all just claim we don't know anything about it, and then we'll go, get one of the officers to smash out Karen's Reed back tail light more, so it makes her look like she hit him. And the problem is that the tail light was modified, right? So why would the tail light be modified, and who modified it to make it look worse? If Karen Reed really struck and killed him, would they be worried about the forensic evidence not lining up, where they had to go back to somewhere at the police station and bust out the light more? No, they wouldn't do that. It's only when you realize, hey, the forensics ain't going to look that good to support the prosecution theory. Okay. And we already know the prosecution theory happened and was told to investigator Paul when he got to the scene. So that's the way things happen. They evolve. They're fast moving events. I don't think there's anything premeditated that day. I think it's something that spun out of control. Some wrong comment was said. Who knows what? But the bottom line is, we don't have to know that to know that the state can't prove their case against Karen Reed. Yeah, the cops did not act like to the protect and serve good guys. No, I mean that's why when I first became a defense lawyer, I did not want to ever be a defense lawyer. I thought I could never be a defense lawyer because I thought you're helping bad guys. You're not against truth and justice. But when I was a prosecutor, and towards the end of my first stint, I saw that there was some problems with the credibility of law enforcement. And then I thought, this is sort of like you're actually upholding the Constitution by making sure the government has checks and balances and how they go after people. And so you're actually It's actually a good thing to have good defense counsel who are doing things by the book, I might add, not to do stuff shady or unethical, but it's good for the process to have some checks and balances. Because you know what? Any of us could be in a situation where we're falsely accused or have a loved one that's falsely accused. And anytime been asked that question, like, well, how can you represent a guilty party? It's like, well, everybody deserves a proper defense because you can have overhanded prosecutions. You can have somebody out of control. You know, what if you had a child of yours that got a DUI and for drunk driving, the prosecutor wants to spend 6 months in the slammer. Okay, would you want to hire a lawyer to fight that, or would you say, hey, sorry, you did the crime, you got to do the punishment? No, you say, hey, you know what? You're in college right now. You can't afford this. It's not normal to get 6 months on the first offense. That prosecutor's out of control. We need to get a lawyer to fight it. Of course, you'd hire a lawyer to fight overhanded and zealous prosecutor like that. But even if they weren't overhanded and overzealous, you want to make sure there's checks and balances in the system, and make sure that there's some honor and integrity in having standards being met. Angela, you're saying, did I see the juror interview Turtle Boy did? What are your thoughts? I don't really want to talk about Turtle Boy. I did see some of the comments. They were all consistent. It was too lengthy of a video to listen to all of it, but all that is reconfirming the stuff I had said back before we found out that any jurors vote was 0 to 12 not guilty on the second degree murder. So it was just so obvious that they have no case for murder against Karen Reed. That's what I can tell you. Joan D, you're asking, could there be an ethics complaint against the judge? She did not recuse herself when she was asked to. I can say that she said she did not have any kind of personal friendship or to have personal contacts with a couple of the witnesses. Apparently, that was put out on social media that the judge is biased because she has friends that are some of the prosecution witnesses. So she got on the record and say she did not have any friends like that. So I would say, I would take that as the truth. So I don't have a reason to believe, there would be an ethics opinion or ethics complaint filed against her for that. But um, yeah, Sherry D, you're saying so many witnesses for the Commonwealth at 34 Fairview, and not one person saw it occur or saw Officer O'Keefe's body. Yeah, that is a telling thing, isn't it? Anna Shaw, you're saying I think Carl's was going by popular opinion. I wish my name was spelled with a K, by the way. It looks more German, like my heritage. But anyway, if you think I'm going by popular opinion, I don't know. I don't even know which side of popularity this is. Okay, I know there's pro and con. I don't really care. And if you really think I'm just I'm sticking my finger up to see which way the wind's blowing, that's what I'm going to tell you is my opinion. Then don't watch my channel. Okay, just don't watch my channel. So Amanda Ronick, you're saying why was the basement floor dug up and the pool filled in? I know they also got rid of their dog. So I don't the pool being filled in. I don't remember that part of it. Could somebody corroborate that? Georgina Biggs, you say why did Karen Reed say we know who did it, and then her last interview with Alan Jackson, they both say we didn't know who did it. Um, I think that that's something I noticed as well. That I think they just don't want to go down that road to say who actually framed them, because then they have to call him as a witness, and then they have to try to prove who did it and all that kind of stuff. So I think that's a bad PR move. I think that's something that um, that you need to make sure that you're consistent. There's not something like that where you have a discrepancy. And so again, you cannot necessarily impute that to Karen. She's going by what her attorney says, so I don't really put that much stock in that. That's what Alan Jackson said. If you notice, when that reporter asked asked him, well, who did? If you didn't do it, who did? Um, uh, they both looked at each other, actually saying, after they both said we don't know, and so that made it look like it was rehearsed. So I don't like that kind of rehearsal kind of stuff like that. It just doesn't lend itself to being credible. But like I say, does that mean um, I think they do have some idea, but how would you know who actually truly is behind this? Okay. um, unless other people start getting charged and people flip. But you got to have some kind of evidence to back it up. But you really had no effective crime scene analysis, right? It was botched from the get go. All right, just jumping ahead here, trying to catch up. Kaikis John, you're saying free Karen Reed. What is the prosecutor's job? Your prosecutor's job is to seek justice, okay? To go after crime, to have cases fully investigated, and once you review the case file, many times you have to ask for follow up by law enforcement because they didn't cross all the T's, dot all the I's, to really make sure you got the right target, the right suspect that you can charge. And then your job is to seek uh, the evidence in a court of law and to present it in a fashion that is credible, reliable, trustworthy, where you can get a conviction beyond a reasonable doubt. If you really believe somebody's guilty and you think the evidence may be iffy or whatever, if you really believe they did it and you don't think there's a more of a delay worthwhile to wait for better evidence to show up, then you could delay it. But I do believe that if the prosecutor believes that there's enough evidence there to prosecute and get a conviction, they always should go forward with that. The problem is you can have other agendas at play. You can have inexperience at play. It can be harmless agendas, like I say, just inexperience alone. But I can tell you the DA's office has under a lot of pressure, unspoken pressure at that, even to support law enforcement. Okay, there's a relationship there that needs to be on a good basis, because if you don't have the cops and the DA's office backing them up, it can turn really ugly really fast, and you need that kind of harmony to have a good prosecution of a case of a guilty party. So just like there's that other case up in Massachusetts of a cop being accused of murder, and that's being pursued by the DOJ because the DA's office said it was a suicide. So that tells you the level of corruption you can see in a city, not only just here in America, but anywhere around the world. Yeah, here, RN. I always send my best and bright associate degree to expert to reconstruct a crash. And think about it. You got somebody's life on the line, whether they be convicted of murder or not. You got a guy like Paul, Trooper Paul. That's a scary thought, isn't it? So yeah, prosecutors are to do justice. They're not just to get convictions; they're to do justice, okay, and protect the rights and make sure the case sticks. They're not supposed to object all the time and try to hijack the good defense questioning and then to say, "Well, we'll let the appeals court sort it out." I objected to everything that could possibly hurt my theory of the case. Andrew, you're saying in my closing, do I explain reasonable doubt to jurors? And if so, how do you do that? By pointing out each possible doubt about the case. Well, yeah, obviously the reasonable doubt is a very crucial instruction. Most of the instructions are along the same lines, which is it talks about having a reasonable doubt is not all doubt. It's the kind of doubt you'd have that would give you a hesitancy to act with respect to your most important personal affairs in your life. So if you have reasonable doubts, like, hey, like, would you buy a car from a salesman if you found out he lied to you on a couple key points about the car, right? If you had your own witness, your own inspector of the vehicle, mechanic, look it out, check it out over, and say, hey, there's a lot of problems with this car. The engine's about ready to blow a rod or something like that. You'd you would not trust them. You'd have doubts about buying the car. Let's just say you're going to buy a house. You're not told about things on the disclosure form, and then you get an inspector to show you stuff on the house, and they show you that there's been some efforts made to conceal the damage done by, let's say, some flooding done in the house because the house is in a floodplain or something like that. So obviously, you're going to have hesitancy to buy the house because you have some things that aren't lining up. You don't trust what is being told to you. So same kind of thing. If you have hesitancy to say, you know what, I can sleep good at night. That's one of the things I talk about. Is I saw many years ago. It was on like a 2020 or Dateline segment where somebody on a jury did what the jurors wanted. They just hurried up and voted to convict. And that night, this person, like, it was a business owner, that night, they couldn't sleep at night because they thought all these reasonable doubt points that they didn't bother to raise with the other jurors. And they basically, they wanted to get back to work, and they didn't want to be like the one man, going against the flow with the other 11. So, but the guy, the more he thought about it, and the more he thought about the defense arguments, the more he's like, you know what, I need to change my vote. So he went down to the courthouse and he uh, said, "Hey, Judge, I need to change my vote. I can't sleep over what I did. I completely botched it, and I did not exercise my conscience when I voted guilty." And the judge said, "Sorry, it's too late. Can't do anything about it. We're not going to reopen it. Your vote was final." Then then this guy went to the DA's office and said, "Hey, I screwed up. This is a mistake. I got to change my vote." This guy wound up, having no hope of having anybody listen to him say, "Hey, your vote's final. You can't change it." So your time to have doubts and uh, and serious deliberation about the case was in the jury room, not afterwards. So you know what this guy wound up doing? He wound up hiring a defense attorney, an appellate defense attorney, to fight for this guy. He spent like 25 grand for a defense attorney to fight for this guy on appeal. And while it was a pending appeal, the accuser who falsely accused him confessed to the false accusation. And in the end, this guy, this guy wound up, being convicted, spending time in prison because it took a while for this all to be ironed out, all because his juror didn't do their job. So what I do is I retell that story and sort of the same fashion I'm telling you now. And I say, do you all agree to have your doubts now so you don't have to spend 25,000 or 100 or 200,000 or $1 million to clear your conscience so you can sleep at night? So that's what I do to make the jurors really think that, hey, this is serious, and you think you're just going to go with the flow and not take your job serious. So I bring that out. I bring that out in another version in my opening. Excuse me, not my opening, in the jury selection process, the voir dire process, as well as in my closing. So I hammer that home, and yeah, I point out all the doubts of the case, and I argue that I proved that my client is not only not guilty, I proved that they're innocent. So that's normally what I argue. So even though I have zero burden of proof, that and I equate it a lot of times to the football field. I say, the prosecution, the presumption of innocence here, it's almost similar to, like, not only we're not on the 50-yard line and the prosecution has to drive it 50 yards for a touchdown. I a lot of times equate it to, like, the prosecution is starting in the back of the end zone by up in the stands, and they have to drive like 120 yards to get a touchdown. That's sort of like what the presumption of innocence about. And as someone recently commented, oh, there's Leo. As someone recently commented, it's like, we on the channel, I think in the last week, it's like, instead of always talking about presumption innocent, how about we talk about presumed uh, that you're falsely accused, right? That's another way of saying it. The presumption of innocence actually means that you've been falsely accused because, after all, the charging instrument, the indictment, is an accusation, right? And there had to been somebody that's accusing somebody of that crime. So if you really are innocent, then you are falsely accused. So anyway, I think that's a telling comment to make as well. So yes, I do point out all the different details of doubt. And then a lot of times what I do is I ask, I tell my opposing side, if I'm a defense attorney, I tell the I dare the prosecutor to address these reasonable doubts. And to this date, I've never had a prosecutor address my big reasonable doubt points that I raised. So, and then I also say that if they don't address these points because they can't, then that confirms that they know my client is not guilty. And I don't say my client ever because that sounds to me too much like you've lost your objectivity. So I never say my client in court at all in front of a jury. So in any event, that's enough on that. Sorry if I got a little bit long winded on that. Daniel X, you're saying, I mean, everybody goes and snatches their SIM card in half and throws it away on a military base when they have nothing to hide, right? Yeah, I mean, you could go on and on about how evidence was handled, how they show up to get their phones scanned or throw it away right before the phones are going to be apprehended. So yeah, there's a lot of shady stuff going on here with law enforcement and other witnesses that were not actual cops on duty, but cops like the one we heard from with Albert with almost 30 years. Yeah, his testimony. I could talk about that too in an upcoming show where his testimony is like really, really out there. Did not find him credible on a number of points. And him having testified about 100 times, he knows better. Okay. Yeah, Kerry Johnson, the truly sad thing of this whole thing is we'll never get justice for John O'Keefe. Karen Reed did not kill him. Well, unless the FBI comes in and cleans house and gets to the bottom of this, that's the only way. Because right now, the state's office is so compromised and conflicted. That's a good one. Yes, I always delete the Sally Port video, and when I keep it, I invert it and don't mention it. Yeah, because think about it. You invert it, and you're messing up the prosecution of a guilty party. Why would you mess up and invert a video that clearly shows that the tail light is damaged to the extent that it's consistent with somebody that was struck by it and killed by it? So there's only a need to manipulate evidence when the crime scene does not match the forensics back in the station. Okay. Hello, Sunshine. You're saying the Fed's investigation is over and no one has been charged. Karen Reed's the correct suspect. Well, you don't know they don't have sealed indictments. Have they made an announcement that of anything to that effect? So I think there's still more to show on this thing. I would say that there's that is not in and of itself an indicator that Karen Reed's the correct suspect. Maybe they don't know who did it. So and they don't have enough people. Too many people have lawyered up. And so, why does Albert have a cop? That's one of the questions I would have asked if I was Alan Jackson. You have a lawyer? You're an innocent bystander in this whole thing. John O'Keefe didn't even show up at your doorsteps, and you got a cop, a lawyer showing up in court that you've been paid. How much money did you pay for that lawyer? So that's the kind of stuff that's fair game on defense prosecution. So thanks, Sherry D. Yeah, Sister Journey discovering the truth, not merely secure conviction. It's about making sure justice happens. It's not about railroading people. Snake Hips is back here. Is it possible she had him beat up and then dropped out there in the snow? I mean, that's a theory that's possible. That's not what the prosecution's presenting, but that's more consistent with the injuries, I would say. So, um, they have to have a theory that makes sense, that's believable. They just can't throw up some theory that doesn't align with forensic scientific evidence. Rosemary Gallagher, you're saying Brian Albert had the basement floor jackhammer, then probably put the concrete into the pool before filling it, then sold the house. I mean, those kind of things, if those are accurate, then those kind of things do look very suspicious. I agree. All right, let's see here. Yeah, Sallyport Secrets. You're saying blood spatter expert and police procedure. I'd like to see. Yeah, that blood spatter. I think they didn't really have any blood spatter there to reconstruct because of the snow and stuff like that. So I don't think that'd be possible. Police procedure, crime scene, stuff like that. That's definitely something they could use. But it's so. I mean, it's almost like you don't need that. It's so obvious. Um, the thing was so botched. Jenny 33. It's not. Is it not unfair to allow the media to double down on lies with no reply from the doctor or the lawyers? So we'll see. I don't know. I mean, I would say I thought it was odd that Alan Jackson didn't stand up afterwards outside the courtroom like normally he has a lot to say. He didn't have a lot to say about this. So I don't know. I don't know what's going on, but it's like I say, what if he did anything wrong? That's not imputed to the client. Okay, Mary Allen, you're saying I believe Karen is guilty. MS diagnosis is very reflective of mood instability and impulsive behavior fueled by alcohol intoxication likened to a blackout moments, our brain's defense way. Okay. That's you can believe that as well, but I'm just telling you from in a court of law, this kind of evidence would not survive scrutiny with a jury, and neither with the court of appeals, even if a jury did find her guilty. So that's the bottom line. Empty pockets. You're saying I've had many car accident involving a car with a person. I've already had broken bones. You know, there's one thing I can tell you. I was once when I was in high school riding to a football practice. I was pedaling my bike down a hill as fast as I could go. So I guarantee you I was going over 20 miles an hour, or at least 25 miles an hour. And all of a sudden a semi braked and cut in front of me. And I wound up, it's a good thing I had my full helmet on. I had a full cage mask, double bars right over my eyes. And that thing got all smashed to bits. And so imagine that what the bones out have been to my face hitting the back of a truck like that. So for John O'Keefe to have his kind of injuries, nothing on the face, and then anyway, it's just trying to have the investigator Paul describe how his body got contorted, the way it wound up, and all that kind of stuff is just this is absolutely it's absolutely ludicrous that anybody would put any stock in anything he says about that. Sherry D, you're saying so much information, misinformation out there. Fed investigation is still going on for sure. Yeah, we don't know where they're at with it. They don't tell us that kind of thing. Yeah. So why did that ATF agent go to the Sally port at 1:30 in the morning? Can you explain that? Doesn't make any sense. Something's up there. On Enterprise, you say they pinned the rep on her when she asked out loud if she did it. So okay, Anna Shaw's why was she going 24 miles an hour in reverse to begin with? Okay, that's do we know that's the actual GPS indicator saying that she was going 24 miles an hour, or is that the vehicle tire rotation speed going 24 miles an hour? That's a distinguishing factor there. Okay, YouTube code. You're saying the cold weather and snow stop the swelling as soon as possible. Okay, um wow, that's interesting. So no broken bones either. How do you account for that? Sherry D at 50 miles an hour, 1,000 pounds of force. When John Officer O'Keefe's had a broken elbow, dislocated shoulder. Yeah, totally. I mean, how they came up with this arm thing and being launched 30 feet. There'd be some massive breaking of bones and bruises and whatnot while he's laying there dying. Andy School, you're saying the force to his head caused parietal contra coupe brain injuries before herniation. The angles are off on every theory uh, Commonwealth had. See, that ties into what I was saying. If you have like a brain trauma expert, a neurosurgeon, talk about his brain injuries and stuff like that, and what he's seen. Somebody that works in maybe in the ER would be also a good person for that to talk about the fact that these kind of injuries you never see from a motor vehicle on pedestrian accident or intentional strike, whichever the case may be. GFK2, you're saying, how do the experts exactly know where he was standing? That's another thing that they're all just assuming everything's truthful based on where they found him and where they saw that there were broken some broken tail light pieces, but they also found him on his body and stuff like that. So anyway, it's all just wild speculation, nothing concrete. But Trooper Paul's acting as if it is concrete, proven evidence. Yeah, this is a dumpster fire case. Yeah, LEV agrees. Fuel flies SUVs asinine. Yeah, Leah, you said you get a Lexus specialist, somebody that does body work and stuff like that. But I think the experts, they got it really enough, because that's what they do for a living, is they really put all this together. Listen, Em, you're saying, according to someone close to the defense team, the bill for 23K was reimbursement for ARCA's travel costs for the 2 trips they made for trial. If so, would they be in trouble for that? Well, if it's a reimbursement and they not paid them ahead of time, then that's also, unless that was agreed to ahead of time that they're going to reimburse them, and then they're misrepresenting to the court and the jury that these guys were not getting paid. They're just doing it out of their, you know, goodness of their hearts or whatever the case is. Kathy Prosser, you're saying injuries are not dog related, snowplow related, Brian Higgins related, in my opinion. So, yeah, I mean, a snowplow, could that cause a type of injuries on the arm or something like that? Um, so that's more consistent. That and or a dog are more consistent with anything about that vehicle. Yeah, I mean, I think that I've talked a little bit about defense lawyers. I think one of the things I'm thinking off the top of my head is like Alan Jackson um, did not really give a scathing cross on Trooper Paul like he could have. I thought he was just going to like rip him to shreds. He didn't do that. I mean, he pretty much did it himself. He didn't come across as credible and knowledgeable, especially when he decides that compared to the defense experts. But in the end, I think Alan Jackson is um, a guy that's comes across likable. I think it's always important to have a likable attorney representing your side. So I think he's a likable type of guy. I think the other guy from, I believe, is from New York, Yannetti. I think he's not as much of a likable kind of guy in front of a jury, but he's not doing as much. But ultimately, what the jury is looking at is the evidence that's presented, the type of questions that are asked, and how the witnesses stand up to the scrutiny that's posed to them, whether it be prosecution or defense. So um, I would say that's. I hope he gets tougher on different cross examination aspects, both for Proctor and Paul. I mean, these guys and and some better cross examination settings would just be absolutely ripped to shreds. And so that did not happen. But I think their own words sunk themselves good enough. But man, that's stuff that Proctor said, for example. That is like golden as a defense counsel. To get that kind of stuff being said about the defendant there at the table. Wow, you'll not find a more biased, prejudiced investigator on a case, in the history of criminal cases. So okay, Sallyport Secrets, you're saying Crash Daddy Wolf was a Lexus expert. Lally objected. He went to Cyber and AJ couldn't question about that anymore. Uh, that I can't remember those kind of details on Wolf, Dr. Wolf, but yeah, I mean they did actual tests with the exact same tail light as on that car. So Listen, you're saying there's no date or time sense on Lexus vehicle data that should have been there, but it wasn't. So, okay, well, if they can't say what time that 24-mile-an-hour backup thing is, then I guess they'd have to look at other video, um, or they can presume it wasn't necessary at the time of that evening, right? So, Mr. Monk's University, you're saying, understudy, you're saying, what can the defense file in order for ARCA to be allowed to say more this time? I would just file some kind of pretrial motion to make sure that they can uh, get this expert testimony fully expanded. It is so like they're just letting a sliver of the information in on how much these guys have to say about the case, and uh, and so that's what bugs me about prosecutors when they don't want the whole truth coming out. Um, they try to block it, and they don't allow the fact that these experts can say there's zero evidence that's that would support this vehicle striking Officer O'Keefe. And if there's zero evidence that supports that, it's more than just consistent. It's an open and shut slam dunk case. Okay. Okay. Miriam Komugi again. Does anyone who's lived in a place where it snows would know the taillight was planted evidence there was zero pieces found at 6:30 a.m. when the snow was only a few inches. Um, those are flat pieces. So is it possible that they could see them? But if they're looking for them and stuff like that, I guess it would depend how much snow fell between those different key points of that evening and morning. So that's maybe why the prosecution's bringing a weatherman to say, hey, the snow was that deep, so it would have covered these small shattered pieces of the tail light. Jenny 33, you believe that Hank Brennan's playing stupid? He knows well he has no case. I don't know why he would stay on this case and agree to do this. The bottom line is he's not going to get a murder conviction out of it. So, but he's getting pretty decent pay. I think he's got over what is it, $130,000 so far. Somebody was saying. Don't know the truth of the actual dollar amounts, but to leave a private practice to do that, as I've said before, is very suspicious. Richie Aunt or Aunt Rich Auntie, you're saying can Kenry be convicted if the medical examiner and prosecutor don't agree on the cause of death? Well, that's the trouble right there. If they can't agree on the cause of death, then that can be reasonable doubt in and of itself. So it's like I say, they're trying to prop up something that doesn't exist on truth. Okay, Mary Room Mine, you're saying don't forget new videos of the SUV backing into the Sally Port just turned over. Yeah, that'll be very interesting indeed. Yeah, that's a good summation. Solo cups for collection of somebody that was murdered, a law enforcement officer at that. They got a leaf blower. These texts from Proctor Paul, the investigator, crime scene reconstructionist guy that has no clue what he's talking about. Nobody's went in the house to do any kind of analysis. Yeah, it's just on and on kind of stuff. So we're at the 2 hour mark here. So I'm going to go ahead take one last question. Thanks for good questions tonight. Yeah, we got a few trolls tonight. I'm not worried about that. Okay. So, okay. You're saying here, hello, sunshine, day 6 of the trial. Last 7 minutes video shows the tail light is missing at 8:23 a.m. Okay. Well, there's other photos that don't show that the same way. So, why people get so hateful and personal over this case so it doesn't affect them whatsoever is the weirdest thing. Yeah, I think, I mean, we can talk about the evidence and we can take sides, but let's thank you for guys keeping it professional, not going with scorched earth on people. We don't need to go there. And so thank you for keeping it um, a proper legal discussion about the case. And so with that, I'll be covered more on this case, I think, because the more I look into it, the more there's a lot of head scratching, troubling things. And with trial coming up, I haven't decided if I'm going to cover the entire trial all day long as the evidence is presented, or just do a recap each night. So remains to be seen, but I look forward to covering more. So thanks for your support for justice, and have a great week. Thank you. Good night.